just interested people in general. So it's exciting for me to be here and be to sort through some of these things. To provide a little more background, I was licensed in 2010. I started out at Lone Star Legal Aid in Houston. That's public interest law firm. And I learned a lot about landlord, tenant, and consumer issues there. Became a solo in Austin around in the summer of 2011. Did that for a while. And then in 2019, I guess it would have been beginning of 2019, started with Amini and Conant, went full-time there, summer of 2019. And I've been working with them ever since. Like it was already mentioned, I do consumer law, real estate, decent number of real estate disputes. Naturally, we have a lot of landlord-tenant disputes, both residential and commercial happening. So that's my substantive background. And when I'm going through some of these changes to the rules, you might notice I might not talk too much about what you might want to do for a family law case, or maybe not so much personal injury, because I don't practice those areas that much. I have dabbled, so a little bit of experience, but I usually don't do personal injury family law. And I know a lot of you probably work for attorneys that practice that. So but at any point after I finish a topic, the idea will be for me to stop and field any questions that y'all might have. So jump in there with any and all questions. If it's something particularly specific about family law or personal injury, I may not know the answer right off the top of my head, but I'm happy to try and discuss it to, explain it the best I can, given my practical experience. Okay, so we'll go ahead and get started here. As everyone knows, the Supreme Court decided to propose and then pass a lot of changes to the rules of civil procedure. They're mainly aimed at discovery, trying to force, I think, all of the parties to, well, I'll start in a second when I actually get there. Force all of the parties to more or less show their cards, dredge up, a lot of information, and in particular, a lot of your documentation that could be relevant to your claims, in particular documents you might use to support a claim or defense early on in the case. And we'll get into some deadlines and things like that, but that's mostly it. It's just going to be probably, we're all going to need to talk to the client early on about what they have, what we need from them, whether we need third-party records, whether we need records only the client has, perhaps we need records a government agency, APD has, if we're talking personal injury where an incident report has been created, things like that. But we want to sort that out earlier, not drag our feet and wait until several months after the lawsuit is initiated to start getting into, oh, there's a poll. Okay. Before you start talking about documents and records and things like that with the client. So they're trying to push everyone to move fast when it comes to disclosing important information, fundamental information, and important documents. But we're going to start with some jurisdictional stuff first. These are all, changes, obviously, but we'll start with the where you want to file after you get a case. Most people are going to go ahead and go to district court, and that makes sense. And I'm sure everyone that's listening to this, they're like, of course, district court, maybe every now and then county court, depending on the case. And sometimes there's subject matter jurisdiction, but here's the breakdown. The big one is justice court has gone from $10,000 to $20,000. County court. Sorry,
Shannon. Sorry. Have you started sharing your screen yet, or?
Oh, I'm sorry. I just realized I may not have done that. Okay, sorry everyone. So I'm actually gonna, I'm not gonna start over, but this was the first slide that no one saw while I was kind of doing the introductory remarks. And I do want to mention that, okay, here we go. All right, here's the slide. Sorry about that. So this is pretty basic stuff. Most people will want to file in district court just to avoid any issues with jurisdiction, as long as your case is worth $501 and more. then that's probably your safe bet. But for the sake of just discussing and noting the changes, Justice Court has gone from 10,000 to 20,000. County Court has gone from 200,000 to 250,000. And naturally, you want to consider the judges. You're obviously the county you're in. I know we have a lot of Travis County, but obviously there's Williamson County, and the other surrounding counties who are all going to have different judges, different local rules, and so forth. Consider that, and just to by the by, this hasn't changed, but real estate disputes and defamation claims have to be filed in district court. Okay, and again, some preliminary stuff before we get into the discovery changes. This is pretty important because it can have repercussions. The other side can get cute with you if you don't enter these required statements. So when you're looking at your petitions, short statement of the cause of action sufficient to give fair notice, that's pretty standard, no changes. And oh, a side note, everything highlighted are the changes or is different from what it was. So that's what you'll want to focus in on. If it's not highlighted, unless there's an oversight or I made a mistake, which is entirely possible, then I'm going over it, but it was the same as the previous rule. Highlight is the change, not highlighted, usually going to be the same. So short statement of your case, a statement, the damages sought are within the jurisdictional limits of this court. And then you have these new 47 statements, jurisdictional statements, whatever you want to call them, but this is what dictates what kind of case you have. Do you have an expedited case or do you have a non-expedited case under levels 2 and 3 for the discovery control plan? So make sure if you're using old petitions back from 2019, 2020, you're going to want to make sure and have a checklist, or make sure you go down this list and put in these different statements, because it's not the same as before. It used to be up to 100,000, from 100,000 to 200,000, 200,000 to $1 million, and over $1 million. Now we have seeks only monetary relief of 250,000 or less, excluding interest, statutory, and punitive damages and penalties and attorney's fees and costs. And this is copied and pasted right from Rule 47. So you probably don't want to editorialize or change these statements, especially if they're in quotes and they're one of the changes. You just need to more or less type it in this way. If you are going to ask for more than 250, obviously put that statement in. Non-monetary relief, as y'all know, is going to be anytime you need an injunction, which obviously happens a lot. You have temporary orders and requests for temporary relief, and it could be in a non-family case, but obviously a lot of family cases, that takes it out of the expedited rules when you start asking for non-monetary relief, and that can be significant. And you can even, in some situations, if you think you're going to ask for non-monetary relief, it's not just about the money, but you also are seeking less than $250,000. If you can come up with a non-monetary request or a request for non-monetary relief, you do not have to go along with the new rules for expedited cases. So you're going to want to do one of these statements, pretty straightforward. And I'll pause right there to see if anyone has any questions about this part.
Yes, I do. My name is Irene Tong. Hello.
Okay. Hello, yes. Nice to meet you.
Yes, I work on the plaintiff side a lot of times, and usually we ask for non-monetary relief, that is injunction, but we also include things like civil penalties over $250. So my question is, why isn't there a category for monetary relief of over $250,000 and non-monetary relief?
Great question. I share your confusion. I have no idea why non-monetary relief isn't just a supplemental request along with each money category. All I know is that if you are asking for more than $250,000 and non-monetary relief, just go ahead and put that statement. I don't think you're going to get have any issues. In fact, if you look at, I guess, the subsection 5 of the current slide, I would say plaintiff seeks monetary relief over $1 million and non-monetary relief. And then you should be fine because you've at least got the statement for both. But for whatever reason, they do not, they have this plaintiff seeks monetary relief of $250,000 or less and non-monetary relief, but they don't have a similar thing for cases between 250 and $1 million and cases over $1 million. And I have no idea what that is. It seems just like sloppy drafting, an oversight. But I think you cover it by just simply making sure you state whether you're under 250, between 250 and $1 million, over $1 million, and seeks non-monetary relief. But it is confusing because the option 5 just says seeks only non-monetary relief when it could be, you know, non-monetary relief and then an amount over 250,000. Yeah, I don't see anyone litigating that or giving you any trouble. I would just be as accurate as possible with the relief you're seeking.
You.
Thanks, Irene. Any other questions?
There is a question in the chat, a couple of questions.
Okay,
Actually, Irene's was there, and then there was one more. What does it mean up from on the amount request?
Give me 1 second.
Yeah.
It was in that first slide. I see. That was the old rule. It used to be 201 to 200,000, and it used to be 1 to 10,000 for justice court. So it's the 200,000 is, I'm sorry, 250,000 is up from 200,000, and the 20,000 is up from the original jurisdictional limit of 10,000, if that helps. All right. Are we good? Any more questions about the Rule 47 claims for relief? Okay. The next change, and I'm trying to do this in order, right? As when you get a case, obviously you started with the petition. So we have the stuff that needs to go in the petition, and then we'll work our way through the different discovery requirements and limitations all the way to the end with the final pretrial disclosures right before trial. And keep in mind, there were a lot of changes to the rules. I'm trying to focus on, I think, the most pressing ones, or the ones that deserve the most focus. Naturally, you're going to want to go through and more or less read through all of the rules that have been changed. I won't cover every single change. I'm just trying to hit the most important stuff where I can see us getting hung up, and where I can see us possibly making mistakes or having some oversight if we don't concentrate on these particular changes. Okay, so for Rule 99, the change there is the citation. This is the clerk's, you know, jurisdiction here. They're supposed to change their citation form to include one major thing. They've got to notify the defendant that the defendant may be required to make the initial disclosures that we're about to discuss at some length. And the actual statement, along with "you have been sued" and all of that other boilerplate that's in citations, is a statement that in addition to filing a written answer with the clerk, you may be required to make initial disclosures to the other parties of this suit. These disclosures generally must be made no later than 30 days after you file your answer with the clerk. Find out more at texaslawhelp.org. texaslawhelp.org is a great website to refer to clients in general, or potential clients you aren't able to help out when you don't take the case. But I recommend people check out that website. It's just another source of information. Yes, it's not, you know, the rule book necessarily, but it kind of summarizes and explains certain things when it comes to, you know, procedure and some of the substantive law, and I think a really helpful and educational way. So anyways, I'm not advertising for them necessarily, but just a quick note on that. So when the clerk emails you or mails you, or I guess we're not picking up these days, but whenever you get your citations, just go ahead and take the time, even though everyone wants to just kick it to your process server. Go ahead and take the time to make sure the clerk didn't screw up and go off of the old citation form for your case when they created the citation with the party names, your case number, your court, all of that good stuff. probably worth adding this to the checklist. Start checking your citations again. Yeah, for everything else, but mostly for this new statement, because Lord knows there's going to be a clerk out there in one of the counties that's going to miss it, or, you know, over, let's say if you've got any citations within the last, you know, first 2 weeks of 2021, there might be something missing there, and it might not matter, but the penalty, if you do not make sure citations have every, you know, precise word and every statement in there is required by this rule, is you'll get a default judgment overturned real quick. Those kind of technical defects, grounds to overturn default judgments in Texas. I don't know how many people have dealt with that issue, but it definitely happens. I've researched this issue a lot about if there's forms, defects in citations, the form of citations, or in service, or in the service returns, then your default judgment will go out the window. So go ahead and double check your citations. Really quick before I actually get off that, do we have any questions about citations in general, or is this pretty straightforward? Okay.
You do have a couple of questions.
I do have a couple. Okay, I need to make sure I can.
I can read them to you.
Yeah, go ahead and do that, because I'm not seeing the chat.
It's fine. Did he mention that bold statement at the bottom of the previous slide about failing to comply with C, the party cannot conduct discovery question?
Actually, I think I didn't mention it, so I'll talk about it real quick. Here's how I think what happens. If for the other side, or you could use this to your benefit, depending, but for the plaintiff side, when you're making the claims for relief, not defending, the defendant, you could send out, you could do your everyone could do their initial disclosures, which is not a matter of being requested anymore, right? You don't have, no one has to request the initial disclosure. These are automatically due 30 days after the first answer is filed. And then you send out your standard request for production, interrogatories, request for admission. 30 days later, you get an objection that you should not have made those discovery requests, or because you did not have these statements in here. Now, that would be a jerk move, but it happens, right? Somebody's like, oh, let's look over the petition. They want to get cute. You didn't make these changes. You didn't enter in these new jurisdictional statements. And, you know, I don't know how picky someone would be. Let's say you don't have the damages sought or within the jurisdictional limits of this court. You don't have one of these statements here. You don't have this last statement, anything like that. If you fail to comply, and actually it's C, I'm sorry. So we're not talking about D or B, that's my bad. It's subsection C. These are the statements you have to include. If you don't, you may not conduct discovery. I have yet to have a party pull that stunt, but that's what can happen with that if you don't have it. Or, you know, 99% of the time, no one's going to, you know, refuse to answer discovery. But if somebody's playing games, that's where that can come in. Sorry for overlooking that.
No problem. There's another question. To add to Shay's question, can defense file special exceptions if the plaintiff fails to plead Rule 47C question?
Sure.
And then
they could do it that way as well.
Do you have language that the citation is supposed to have? Sorry if I missed it. I guess they're wondering if there's a slide that has that language on it, but
no.
That's
Let me
okay.
see if I can.
We can.
You know what I should do? I could get my case text going on the side and then share that. I would just instead of that though, I would look up Rule 99. That's going to have your list of everything. I cut out some of it. Let's see. I'm trying to go back. You see, I have this ellipsis here. There's a lot more information before you get to this last statement that needs to go in the citation. So pull Rule 99 and then put it up against your citations on your monitor. And I think that's a good way to review and make sure you have everything.
All right, thank you. I think that's all the questions for this area.
Okay. All right. All right, so
He's muted.
Sorry. Okay, sorry, one more question. No need to add a request for disclosure in your petition and or answer. It is due 30 days from the answer. What about the plaintiff answering RFD?
Correct. You can put, I mean, you can put a request for disclosures, but it's no longer 30 days after you're served with the citation and petition. Everyone, it has to serve initial disclosures 30 days after the answer is filed. And that's going to create a bunch of other pre-trial deadlines that we're going to go over. But you do not have to request it. The rule is explicit. I don't know. So we're talking about this obviously out of turn, and I guess I can also
It's okay.
stop sharing. Okay, but anyways, but yeah, to answer that question, and that's a good point because we were talking what goes into the petition. You do not have to request. You can pull all of the plaintiff requests all the information and materials contained in text rules of procedure 194 point, what is it, 2? I think so, 194.2 within 30 days. That is no longer a proper request. It's meaningless. I would just take it out, or I would call it something else. Notice of initial disclosures, or create a new section instead of calling it request for disclosures, notice of initial disclosures due date, or there's probably a better title you can come up with, notice of initial disclosures. Please be advised that all parties must provide initial disclosures as required by Rule 194.2. Yeah, Rule 194.2 within 30 days after the answer is filed. Okay. After the defendant's answer is filed. There's some language for you. I should have probably thrown it in the slide, but I would do that. And it probably makes sense to put that kind of quote unquote notice. It's not officially a request. It's just a reminder to defense counsel, hey, don't forget, we have these new disclosure requirements. They're on a new deadline entirely. So, whenever we don't get your disclosures, defense counsel, 30 days after you file an answer, we can say, hey, didn't you see? Didn't you read it? We reminded you. We realized new rules. Sometimes there's going to be oversight. People keep on doing things how they normally do them. But yeah, it doesn't hurt to put some kind of notice. I just wouldn't call it a request. And then keep in mind, you're changing the deadline based on the new rule.
A couple other quick questions. Irene just commented, so in other words, once defendant answers, both defendant and plaintiff will have to serve required disclosures within 30 days of answer?
Absolutely. Plaintiff has to do it too, all on the same day. So right. if everyone's doing it right, you're submitting those to each other on the exact same date, or by the same date. Okay. And then somebody does in the chat, this is for our members, has a citation issued by the clerk that includes the new language, and she's happy to share it if she has her email in the chat. But another question says, my follow-up is, how does this affect discovery served with petition? Are you saying that if C language is not completed, then discovery served with a petition is not in compliance? Yes, the short answer is yes. It's not in compliance because of this. Discovery cannot begin until the initial disclosures are due. Okay. I recommend holding on to your requests and then serving them the day after initial disclosures are due, maybe even the day of. If you do want to go ahead and let them know you mean business by doing your discovery request and attaching it to your petition, you should probably dedicate a section, even as part of the discovery request or in the petition itself, citing the discovery request you're attaching. Say these are due 30 days after the date initial disclosures are due. And then you have your other section that's going to say initial disclosures are due 30 days after defendant has filed an answer. That's one way to do it.
All right, one more question, then we're just going to move on for you so that you can get through your presentation.
Yeah, okay.
Well, what about multiple answers? Go with 30 days for each defendant answer and plaintiffs due with the first 30-day deadline?
Yeah, no, you can wait. If you got defendant individual, defendant company. Defendant company answers first, defendant individual answers after you have to request alternative service, do all this. They answer a month later. You don't have to, that defendant who gets served and answers later, you don't have to exchange disclosures with them until 30 days after the last answer or that answer, if that makes sense. So
Okay.
it's defendant by defendant, 30 days after that defendant files an answer. So you can have several due dates or deadlines for initial disclosures, depending on when the defendant's answered.
All right. Thank you very much.
No problem. Okay. I am unmuted. Okay, good. All right, we'll start getting through some of these, and I might skip through a few or get through a few before I ask questions so we can make sure to keep it moving, because the questions will come up that I'm probably going to answer later on in the presentation anyway, which is natural. That means you are thinking ahead. New methods for alternative service. So some of us have been doing this to begin with, right? You've got people evading service. Lord knows where they live. You do your background check. You can't find a good address. Their last known address in the public records is long useless. No longer live there. The new rules provide for service electronically in different ways now. Okay, I just heard myself repeated. Uh-oh, I've got an echo.
Marshall Martin is not muted.
Okay.
Oh, it means someone's hearing it. It's coming back to me. Okay.
She muted herself and now she's unmuted
I
again.
think that
Okay.
fixed it.
That did fix it. I understand how that logistically happened. Okay, not a problem. Method of service. All right, you try personal, right? That doesn't work. I don't know whoever has successfully served anyone. Certified mail return receipt, which is your other option, but assuming that doesn't work out, unless it's obviously a corporate registered agent like different companies have. Now here's your two alternatives. Personal service didn't work. And this is when you need to start working with your process server. We all need to get on the phone with our process servers, exchange some emails and say, are you aware of the new rules for alternative service? Let's come up with a game plan on how you're going to try to serve somebody, what you're going to put in your affidavit of due diligence on how you try to track them down personally. And let's make sure you're getting your due diligence affidavits right so we can get our substitute service. And then let's make sure we're doing alternative service right. Word on the street is, and I don't think it's much of a secret, I'm hearing the at least Travis County judges, both district court, county court, whoever, are looking at default judgments very carefully. They're trying to make sure everyone to a T, like very strict on making sure you've got good grounds for alternative service and that the alternative service you're proposing is going to be good and actually serve to give the defendant notice of the lawsuit, serve to make sure that they somehow, some way get a copy of the citation and your petition. So this is where you can save yourself a lot of headaches making sure you do this right in case the other side doesn't respond and you're set up for default judgment. All right, so the process server can't track the person down. They enter in all of their attempts, the date, the time, the location, who they talked to, that person's relation, the aunt answered, the cousin, the brother answered the door. They left their card, no one called back. Try again in the evening, try the next day in the morning. That's also, and again, this is stuff that people have already been doing or kind of already know what the judges want on the service attempts, but I would do 2 different days. And then over the course of those days, morning, afternoon, and evening. That usually satisfies most judges that you try to find the person, find this defendant in person, hand them the citation. Okay, so if that doesn't work and you talk to your client or you just know, you go online, you go on Facebook, Instagram, you find out your defendant, you enter their name, you see their picture, or there's other indications that they're using Facebook, they're using email because your client says, here's their email address. You know, they emailed, got into a fight. Perhaps you have a business dispute, a consumer case or something like that. Then you want to along with your affidavit of due diligence. If you're going to request alternative service by social media, email, or other technology, you need, I think it's a good idea to have the client and not the attorney or paralegal create this affidavit, because it helps when the law firm is it a witness on on an issue of service or something like that, or any issues in the case, even though they're procedural in nature. But I'd have the client do an affidavit, and I think this is the next slide. Let me get to it. Okay, this is where I kind of provide statement or other evidence. So shows will be reasonably effective to give the defendant notice of suit. This needs to be in the form of an affidavit, and have the client sign an affidavit that states defendant regularly communicates with a specific email address or regularly uses Facebook, Instagram, Twitter under the name Frank Abagnale Jr. That's the Catch Me If You Can reference for anyone paying attention. And I also think it's good to go ahead and post a sample email, a sample Facebook post, maybe a screenshot of a direct message that your client had with this party to indicate that they've actually used it. And usually you're going to have a date and a timestamp, right, for your email. So make sure that's visible on the sample email or the sample social media post that you're using. That's probably just makes the judge feel a little better that your processor or the defendant will get notice of the citation and petition if they're served in this manner. So here's some example language you put in the affidavit in addition to the statement of they use this email address. Attached to this affidavit is a true and correct copy. Don't forget to always say true and correct in your affidavits when you're attaching evidence of a recent Facebook post made by Mr. Stanfield on January 27, 2021, describing how great his presentation on the new rules of civil procedure went. Okay, so just an example there. And before we get to the discovery, which I probably need to dive into pretty quick, I'll take just one, maybe two questions if you have about requesting alternative service.
Okay.
And I'll make this note just really quick, and then I'll take a question. But your process server obviously needs to specify how they served the person through social media or email. And I think the process server in their affidavit of alternative service should, again, attach the email or the message or the post that they made on social media, providing notice of the lawsuit, the party names, case number, all of that stuff, the message that went in the body that was directed to the defendant. The process server should include that. It's an extra step. Some process servers feel comfortable with, kind of documenting the alternative service in that way in their affidavit and attaching proof of service and things like that. But you need to have a process server willing to take those steps, and willing to document it correctly. So we make sure alternative service was affected according to the judge's instructions. Okay, with that said, any questions?
There's a comment in the chat that says, sounds like service by text message is likely a conceivable method as well. And I accidentally muted you, Shannon, so you have to unmute yourself.
No problem.
All right.
Yes, that's a good question and something I've thought about. I think I did serve somebody alternatively by text once when we didn't have a good email address or regular physical address. So the way to do that is the process server might be able to copy all pages of the citation and petition into the text, and text them that way. Another way to do it is they can upload it to the cloud and provide that person with a Dropbox link by clicking on this link. And they just need to explain in their affidavit how they did everything. I uploaded the citation and petition, and I texted the defendant this screenshot of the text. Text says, you're being served with a lawsuit. Citation and petition can be found at this link. There are very important deadlines that are explained in the citation. Please read this. I don't know, just so you can go over the top with it, but your process server might be able to do it that way if it's difficult to actually copy and paste or attach a big attachment like that in a text message for whatever reason. And of course, it's different if someone has an iPhone versus doesn't have an iPhone. It could depend on what your process server is using. You'd want your process server to state the number that they texted from, you know, just provide all of that information. There's not enough detail when it comes to the affidavits for alternative service, especially in this new world where we're able to do it online by email, social media, or text message, but text message is fine. All right, I'll take as many questions at the end, but I'm just looking at the time, realizing I'm suffering from the same thing that I've suffered before in giving presentations, which is falling behind. So we'll try and start to get through some of these. All right, discovery. Disclosures is the big one that we're gonna go over. Experts, not crazy changes there. We don't have to spend too much time. Expedited actions, the amounts change, but because it covers all claims up to 250,000 now, more cases will fall under the expedited rules. So we're going to go over that. And our big checklist is, do we have an expedited or a non-expedited case? And are we at discovery level 1, 2, or 3? Of course, you get to request that if you're the plaintiff. So we'll talk about strategically. And then we want to look at calendaring all the automatic deadlines depending on expedited or not expedited in your discovery level. So we're going to go through all of that right now. And I tried to make this as practical as possible, thinking of, you know, things that paralegals and attorneys, you know, lose sleep over when it comes to deadlines. It's all about calendaring. We all know what a big part of the game that is. So that's kind of where I'm focusing. Okay, initial disclosures. We've already gone over it, so this will be pretty quick. Unless otherwise agreed or ordered by the court, you must, all parties, not just plaintiff, not just defendant, not just one or the other, 30 days after the filing of the first answer, or if you have a Johnny come lately as a defendant, you can exchange disclosures with a later defendant 30 days after being served as a new party to a suit. I guess that's in a situation, the only reason this is a little odd, I guess what this means is this. So I misstated what the actual change to the rule is earlier. The new defendants can be required once you serve them with citation, right? Because it's separate defendant, separate citation, separate service. I guess if the lawsuit has already started or you at least have one answer on file, now it's 30 days after they're served. So go ahead and take back what I said earlier. I apologize for that oversight. New defendants or all defendants except for the first one that answers, your disclosures are due 30 days after you serve them. If you're the plaintiff, you're the defendant after you get served 30 days on the same date. Like we mentioned before, no request is required. Delete your request for disclosures in all your petitions for any petition filed January 1st of this year forward. No longer. I recommend doing a notice of initial disclosures, and just state that, you know, you could account for both things. If you are if you're the first defendant to answer, your disclosures are due 30 days after that answer. If you are a defendant who is, you know, filed after the first answer, 30 days after you receive notice of this lawsuit, or after you receive citation, because that would be 30 days after being served, right? So go ahead and account for those two situations. If you have to amend your petition to add a new defendant, then you can obviously come up with a new notice of initial disclosures for that defendant, and it's 30 days after being served, both the plaintiff and defendant. And if you've got a lot of documents, there are a lot of witnesses, we all have clients, it's like pulling teeth to get, you know, phone numbers, addresses, any emails or documentation that we may need from them for their case, medical records, you name it. Reach out to the other side and say, hey, we've got initial disclosures, we get it. Do you want to agree to a 30-day extension or 60-day extension? And you know what? You're going to have the other side be more than happy to rule 11 on the deadline for the initial disclosures. Okay, let's get through the content pretty quick here. And I'm just focusing on the highlighted stuff now, especially with the time crunch. Computation of each category of damages claim. This is different than the old rule. This is wanting you to talk about economic damages, pain and suffering, each category of damages as it might be in the jury charge, right? Current pain and suffering, future pain and suffering, current medical expenses, future medical expenses. Obviously, you're not going to know a lot of this stuff this early on, but as best as you can, break everything down by the type of damages that it is. Economic damages based on breach of contract, that's great. Deceptive trade practice claim. Someone gets screwed $10,000 over a lemon car that's sold from a dealership, and you want to pop them for the exemplary damages. You now have a treble damages. That's a separate category. So you have your actuals, your economic damages, statutory or exemplary damages. And then if you've got gross negligence or fraud, you need to go ahead and put in some number for punitive damages or exemplary damages. And then obviously your possible witness name, address, telephone of persons having relevant knowledge. Really quick on the computation of each category of damages. This is kind of part and parcel of the initial disclosures requiring you to produce documents up front. You have to do the same thing with documents that show the nature and extent of injuries suffered. Examples, medical bills, photos of property damages, invoices, receipts, etc. Okay, now here's the big one. Out of everything we've discussed today, this is one to look at as far as new substantive discovery requirement. Is a copy of all documents, electronically stored information, and tangible things that the responding party has in its possession, custody, or control, and may use to support its claims or defenses, or description by category and location of such documents. If you've done any federal work, you're already familiar with what this is about. This is asking all the parties to just put their cards on the table, provide your evidence, your documents, whatever it is to support your claims, defenses, your damages, obviously, right? Number 4, now we need documentation on damages. This is documentation on liability or any other thing that relates to a claim or defense. And then these other required disclosures still required, but a lot of them are not going to be applicable. Indemnity and insuring agreements, settlement agreements. If you're doing a plaintiff's personal injury case, for instance, that's not going to be something you're concerned about. If you're working on the defense side, obviously, indemnity insuring agreements, that could apply. 10, 11, 12, all pretty much the same. Okay. There are now, for family cases, a new set of disclosures. And again, this is due 30 days after the first defendant answers or 30 days after other defendants are served. All documents pertaining to real estate, retirement documents, health insurance documents, most recent statement pertaining to any accounting at a financial institution, kind of showing where the money at and how much is there, right? And then for child or spousal support cases, policy statements, summary description of benefits. This is the healthcare, health insurance type documents, income tax returns, again, revealing financial information that could be relevant to child or spousal support. And then 2 most recent payroll check stubs. For many family law attorneys out there, happy to answer, or family law paralegals out there, happy to answer any questions, but I don't do much family law, so I don't know how helpful I can be other than these are the new disclosures for family law cases. To me, this is going to require you to get with the clients and sort through everything they have. You're going to have to stay on them early and often to make sure they get you what you need. Okay, then we'll do practice tips, and then I'll answer questions really quick. Again, kind of what I already said, get on your clients early and often about providing all of their documentation, especially with family law cases. There's a lot there, but ask for emails, texts, bank statements, medical records, reports, etc. Create a form letter and email, or an email if your client communicates by email, that lists out everything that you need from them. You know what kind of case it is, you know what documents are going to matter, you know what you need from the client. We used to be able to wait a few months and do that. We'd go ahead and do our bare bones disclosures, and then we get around to discovery when the other side requests it. No longer the case. You need to get out ahead of it. It's going to be automatically due pretty quick after the lawsuit's filed and the defendant answers. So make sure and stay on your clients and tell them it's very important you have this information. And if they do not cooperate, if they do drag their feet on providing you what you need, whether that's information or documents, tell them their case is stalled. You can't do litigation. You can't have a deposition. You can't set the case for trial. So this is just going to be more of client management than anything else. But also keep in mind that you do not have to, break your back trying to get documents that are not in your possession, custody, or control, or in your client's. possession, custody, control, and you don't have to produce documents unless they may be used to support your claims or defenses. So if you have a lot of text messages and emails that are not helpful, and you would never consider introducing them at trial to help prove your case, then you do not have to disclose. You wait for the other side to do their discovery request, asking for all relevant information, and then, subject to any objections, you disclose everything else. So it's just the good documentation, the supportive documentation for your case that has to be disclosed early on. Obviously, doesn't include third-party records. And again, if you cannot gather everything in time, talk to the other side about a Rule 11 to extend the deadline for the initial disclosures, or you can describe by category and location, which I guess you just described, emails between these parties from this date to that date, are currently in the client's possession, or on the person's email server or something like that. If we're talking, you could medical records, obviously the hospital or the service provider could be in possession of those. But if they're not in the client's possession, custody, or control, excuse me, you don't have to account for those, and just either you don't have to disclose or you don't have to describe by category and location. Okay, really quick, any questions on that?
I don't see any questions, and I freaking accidentally muted you again. Sorry.
Okay. And maybe
Oh, sorry. One more. Pretrial disclosures required? Question mark. Not sure.
Let's see. Is that
That's
you can unmute and pretrial disclosures? That's a separate category. 30 days before trial that we'll get to.
okay.
But that's not, these initial disclosures are just the beginning of the case, and it's just limited to this specific information. All of this stuff right here that we've gone through. This is the list you need to memorize and then send to your client. Any other questions on this before I moved on to testifying experts?
Go ahead.
Okay. Okay, things start to get a little sticky with the testifying expert disclosures. And by the way, these numbers, I'm putting 194.2, 195.5. That's obviously the rule of civil procedure. And then at the end, I'm going to have a list of all the rules, the main rules that you're going to want to look at, review, and learn that contain all of these changes. Okay, so for testifying experts, plaintiff needs to designate the expert and provide all of the required information 90 days before the discovery deadline. And in a second, we'll get to how we calculate discovery deadline depending on the type of case. But first, you need your discovery deadline. For most cases, that's what you need to establish first. You need to find out if it's an automatic deadline or if it's something that needs to be part of a scheduling order. It's going to be one of those two things. Level 1 and level 2, we have automatic discovery deadlines. Level 3, it's based on a scheduling order with a trial date. Typically, the parties will agree to finish discovery 30 days before the trial date. And these deadlines need to be plugged in automatically. You don't need to wait. 90 days, plaintiff designates their expert. 60 days before discovery ends, the defendant designates their rebuttal expert. If you haven't retained an expert, let's say it's a treating physician that would be horrible on the witness stand, all you need to do is designate subject matter on which they will testify, which is obviously this person's injuries, right? Their treatment, so forth, so on. And then a general substance of experts, the general substance of the experts, mental impressions and opinions, blah, blah, this is standard from before, this language hasn't changed, or if the expert has not retained documents reflecting such information. So if we're sticking with personal injury, what's that? It's the doctor's notes, discharge, the chart, all of that good stuff that represent what the doctor thinks of this patient, that injuries and the treatment. If you're retaining your expert who's going to review all of the medical records and talk about how long it will take before your client can work again, and I'm just using obviously personal injury as an example, you have to provide all this information. All of this is pretty standard. All documents have been provided to the witness or have been reviewed, your expert's resume and bibliography. Here are the new requirements. Experts qualifications. This is important. And this is what you need to send to somebody you plan on retaining early on, or you need to consider if your expert has some of these required disclosures early on, because it could be used against them. If you have an expert who doesn't have many publications, or might not have the credentials, the experience, and the knowledge you want, then they won't be able to provide too much in terms of these new disclosures that are required. So lists of all publications authored in previous 10 years, all of their cases expert testified in during the last 4 years. Obviously, this can be used to get an expert's. You can try and get other deposition testimony. You can try to get your trial or hearing transcripts. You can pull the case and see if they, did any affidavits. You can use that to impeach them, cross them up on what they know and how they know it, and so forth. And then the other new one is a statement of the compensation to be paid for the expert's study and testimony in the case. That doesn't have to be the actual contract that you enter in with your testifying expert for their services. It just needs to be a statement of the compensation to be paid. All right, $350 an hour for, all deposition testimony, $450 for trial, whatever agreement you have. If you have an expert that has not provided a report, now the plaintiff, defendant, whoever party can move for the court to order the expert to produce a report that explains their factual summaries, data, calculations, and their opinions, how they arrived at their expert conclusion. You can actually make them do homework. If the other side designates an expert but does not produce a report along with that designation. And what do we got? 1255. Okay, so number 3, if no plaintiff's expert report provided by the deadline, you must produce plaintiff's expert for a deposition 15 days before the defendant's expert deadline. Just get a report. Find an expert who's going to provide you with a report. So after the 90-day designation for the plaintiff, 60-day designation for the defendant, then we do depositions with everything above board. We've got a plaintiff's report, we've got a defendant's report perhaps, then we do depositions. Otherwise, you've got to get in there and let the defendant depose your plaintiff's expert before their defendant expert designation is due. Okay, here's pretrial disclosure someone mentioned before. This highlighted information, it's new. Again, plug it in your calendar. All this highlighted stuff with these new deadlines that didn't exist before, it's changing everyone's calendar. It needs to change everyone's procedure for how they go about establishing discovery deadlines and all of the deadlines they need to enter before all of these important dates. And your 2 big dates, your trial date, your discovery deadline, right? That's where all of these other pretrial deadlines are going to emanate from. So 30 days before trial, witness lists, exhibit lists, and you can read through that. You can go look at Rule 194.4, but you need to have that ready to go 30 days before trial. As we know, you can get away with only providing your witness and exhibit list maybe a week before trial, maybe 2 weeks before trial. I don't have all of the Travis County District Court's standing order memorized, but this, I think, conflicts with the deadlines provided by the local rules. And guess who wins between the local rules and the state rules? The state rules win. They beat all of your local rules. So you start with this stuff, then you look at the local rules, which should soon be amended to incorporate all of these changes. Oh, and by the way, make sure you've supplemented and amended all your discovery responses, produced everything that you should have produced to begin with. If for some reason it got overlooked, or there's new documents that were not produced 30 days after the initial request, make sure all of this stuff is done 30 days before trial. All right, so to get through it really quick, here are your discovery control plans. Expedited cases, initial disclosures due 30-day after answer is filed. We'll just assume one defendant. Discovery begins when initial disclosures are due. That's for all cases. But for expedited, discovery ends 180 days after disclosures are due. So when you get your first answer, you count from 30 there, and then you count 180 days after that for your discovery deadline. And guess what you can do after that? Now you have your testifying expert deadlines, 90 and 60 days before the discovery deadline. So this is all the stuff you got to make sure and plug in. It's automatic. It's not a scheduling order anymore. These are just automatic deadlines. Limitations, only 15 requests for production, 15 interrogatories, 15 requests for admissions, 20 hours total for all witnesses, either to examine or cross-examine, and any party can request a trial, and the court has to set it 90 days after the discovery period ends. Again, that's why you want to make sure and get that discovery period down quick. Level 2, this is the default rule, as we all know. Again, initial disclosures 30 days due after, 30 days after the answer is filed is when they're due. Discovery in 30 days before trial if it's a family case, or if we're not talking a family case, we're talking personal injury, real estate, commercial, consumer, 9 months after initial disclosures are due. Boom, we just have established a new discovery deadline, and we have all of these other deadlines from there. Or 30 days before trial for non-family cases. No one sets trial that quick. So if it's not a family case, your discovery deadline for your standard discovery control plan level 2 is 9 months after initial disclosures are due. And again, kind of going back over, expert disclosures due 90 days before discovery ends, rebuttal expert disclosures and designation 60 days before discovery ends, no limit on request for production admission, 25 interrogatories, 50 hours total to examine and cross-examine all witnesses. And if you have a scheduling order, that's great. But until you get that scheduling order in, I'm thinking you defaulted to level 2 until you enter in different deadlines, whether it's the end of the discovery period, and then based on that, when your expert disclosures are due, if you do request discovery level 3 because you want to avoid the automatic deadlines for expedited cases and level 2 cases, that's great, but you need to set a trial date quick after the other side answers. And then from that trial date, you need to circulate a proposed scheduling order, submit it to the court, get it signed. Anything not addressed in that order is going to be subject to the default rules and the new there. So, okay, summary, here are the rules. This is probably something you want to take down, or obviously everyone will get an updated PowerPoint presentation. These are the main rules that I discussed today. And if anyone is interested in any questions, I'll take those now. I just realized I used up all my time, but I'm happy to stick around if anyone has questions.
That's fine. There is a question that says, if plaintiff ignores the new rules and sends discovery requests with their petition, how would you handle? Respond with something to CYA, cover your ass?
Yeah, I know what CYA means. No,
in case somebody does.
Yeah, in case someone's confused. That's the lingo, right? That's professional lingo. Yes. Here's the thing. You can always just agree to answer discovery and not lodge every technical objection based on these new rules. So do it case by case. If you don't feel like, if you're on the defense side, you get a bunch of discovery requests for the plaintiff and want to wait dealing with discovery until after the initial disclosures are due, just kindly, send an email, pick up the phone, talk to the opposing counsel, talk to their, the law firm, whoever you're working with, and just simply say, oh, okay, hold on real quick. I got to see what the answer is to the, what type of shoes am I wearing? I'm going to show you too. I'll prove it. All right, 5 more seconds, and then I'll finish. I think I answered that question, but 5 more seconds. You guys are, all right.
What are they?
There it is.
Oh, flip-flops.
Flip-flops. So I don't know if 9 or, oh, now someone just voted on flip-flops. That's cheating. You should have shut down the poll. Okay. It's a matter of discretion. You can go ahead and see, answer it, or just kindly say, listen, here are the new rules. We would like to follow the new procedures that exist. So we don't have a problem responding to your discovery, but let's go ahead and do that after the initial disclosures are due. Send them an email, pick up the phone.
All right, one last question just to clarify, because there's a lot of chatter on the chat about this. These new rules only apply to cases filed on or after January 1, 2021. Cases that were filed and waiting for service, answer, etc. before January 1 are still subject to the previous rules, correct?
My understanding it's just filed. It doesn't have to do with service. If you filed before January 1st, 2021, these rules do not apply.
And that's what some people are saying.
That's my
in the chat.
understanding. Now, I could have misread the official rules that came from the Texas Supreme Court, but that's how I read it. I read it as filed.
Right. And you already answered this, but we can still enter an agreed scheduling order for any level case to set schedule outside of these rules, correct? We can agree to.
Oh, absolutely. I mean, if it's a level 2 and you enter a scheduling order, that's fine. The scheduling order will control. And I like scheduling orders just because there's no mystery. This labyrinth of different automatic deadlines, depending on the different discovery levels, expedited, is it family, not family? You resolve all that with scheduling orders. I wish that the courts force the parties to do a conference and propose a scheduling order at the beginning of each case. It would be amazing. But Travis County, we currently don't do it that way. Other counties don't do it that way. Some do, but a scheduling order trumps everything if you get the judge to sign off on that.
Okay. All right. I think those are the main questions. Anything else you want to add, Shannon?
I think that's it. I will go up to the first slide where I think I have my email address. If someone wants to shoot me a quick email or call. Yeah.
All right. And we're
Shannon, Eddie,
your
Amini,
latest
Conant, direct
version.
number, feel free.
Okay. And we'll upload your latest version, the one that you presented today, to our speaker zone.
Sounds great. Thanks for having me. I enjoyed it.
Thank you. All right. So very quickly, I do have a random generator up on my other screen, and I'm going to pick a couple names. We have some gift cards to give to people. So the first one was Kathy Mendoza. Is she still here? I'll find your contact info if you are. Kathy, anybody see Kathy's name on there? She might be gone. All right.
She's there.
Oh, she's here. All right.
I'm here. Sorry, I couldn't find my unmute button.
Okay, awesome. And then the second name, I just hit it again, is Nellie. And I know Nellie's here because she's been active on the chat. All right, so you ladies are going to get an email with a link for you to choose a virtual gift card.
Oh, thank you.
And yeah, just to go over briefly our upcoming events, we have a board meeting on February 11th that everybody is invited to attend at noon via Zoom. We have a pro bono and community services meeting February 6th. Please join us for a special presentation by Crystal Massey, the volunteer engagement coordinator for Immigration Justice Campaign. She's going to tell us about some opportunities. Next month's speaker is the Travis County Domestic Violence Training Attorney, Kimberly, to present on the new law requirements and regarding protective orders. And in March, we have the Honorable Judge Karen Crump, who's in a Zoom jury trial right now. So you can always look at that right now if you want to check it out. And she is going to present to us on Zoom jury trials. So if you don't know how to look up on the internet, how to find the YouTube channel for the Travis County Courts, if you email me, president@CAPA.tx, I can send you a link, but it's pretty easy to find. Thank you guys for attending. This was really informative, and you can always email us, fill out the survey, let us know if there's some other topics that you want to see on these virtual CLEs. But we are adjourned, and thank you everyone again for attending.
Thanks, y'all. Appreciate it.
All right, bye-bye.
Thank you.